We pray your blessings on our gathering today. Give us wisdom, guidance, Lord, as we look at the agenda before us. And we thank you for all your blessings. In your name, amen.
Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Would the clerk call the roll, please?
Robert Inserpi.
Here.
Richard Donnelly. Roger Brunswick.
Here.
Barbara Craig.
Here.
Chairman Kurlander.
Here.
Russ Wynn.
Present.
That'll be different, huh?
There are no minutes to approve. We'll do, from the last meeting, we'll do that at our next meeting.
They didn't call her.
Debbie, I'm going to do that.
Oh, I'm sorry. Forgive me.
So before we get started, I want to welcome to the zoning board Dawn Konikowski, who is our newest member. You sit in the seat formerly occupied by Jim Worcester, who I believe you know, who was a great contributor to the board, and we hope that you will be too. Welcome.
Thank you very much.
This is a time for public comment. Public is entitled to comment on any matters before. I would recommend that if anybody wants to talk about the matter, the case that's being heard today, that you wait until all the evidence is presented. We'll have another public comment period, and it affords a better context for your comments. But if you want, you're free to comment now. So is there any public comment? Hearing none, we'll call the case a continuance from the November 19th, item 7B, the Bonita Grand Mine Industrial Plan Development Amendment.
Thank you.
Before the meeting, I asked the three council, and I'm disclosing this as an ex parte communication, that I discussed with them whether or not this case should stand on its own or should be combined with the case that's potentially behind it, potentially, and under what rules we would operate, and whether there was a possibility that if we heard both cases together, we could then do it under Bonita Springs law, and apparently that's not going to work for the applicant. Bonita Springs does not allow mining, Lee County does, and they're entitled to be heard under Lee County. And we are obligated to follow the Lee County law. So would somebody, one of you, David, perhaps Theriak, counsel for the city, bring us up to date as to where we are in this process? And
Certainly, thank you. Again, David Theriak, I represent the city staff today. A little bit of background information. The BG Mine entity has sued the city in 5 different lawsuits, ranging from a host of issues. After months of negotiations with BG Mine, the representatives, the owners of BG Mine, we were able to recommend a settlement agreement to the city council, which the city council has approved. And the very first step in the settlement agreement is what's before you today. And that was one of the things that was negotiated during the settlement process. And the applicant had submitted an IPD amendment to expand the area in which they could mine, and also to extend the expiration date to coincide with the DEP permit that they have, which expires, I think it was 2041? Yeah, 2041. Right now, as a result of the governor's executive orders, I think they have an expiration date of 2035. So we're really looking at just a 6-year extension from where they are today. So what you have before you is an application. Because the city has not assigned a future land use map designation and has not assigned a zoning designation to the property, This application is subject to the Lee County's regulations. The city annexed the property but never took those next steps. And they're entitled to have their application heard by y'all. I believe there was a first reading by the city council already, and then tomorrow will be the second reading on this application. And the time frame was part of what was negotiated. The applicant desired a decision by December of this year, a final decision on their IPD, which is why we went to city council for a first reading. It's here before you for you to weigh in, and then tomorrow will be the city council's second hearing on it, so that we meet the time frames of the settlement agreement. If for some reason the IPD amendment were denied by the city, I believe the applicant would have the right to say that the city has breached the settlement agreement, and then we're back in the 5 lawsuits. And some of the things that we got in the settlement agreement were pretty significant for the city, including a city park at the top of where the BG Mine property is, and then also acquiring some other property for stormwater management benefits. So it was a give and take process to reach where we are. So today is that first step to implement the settlement agreement. Derek, do you have anything you want to add to that?
No, I don't have anything I'd like to add. What I think part of your question also is why the IPD now, if under the terms of the settlement agreement there is a future comp plan amendment and an RPD which allows the mining uses to continue. It is my understanding that the purpose of that is the way our settlement agreement is drafted is that it is based on a number of contingencies, that if the approval doesn't go forward, then the settlement agreement, everyone goes back to their prior positions. If the RPD doesn't get approved later on, which would be sometime in March or maybe as late as June under the agreement, then I think that what the applicant is hoping for is that they have at least their existing rights vested. But I'll ask the applicant if they want to add anything more to that. But that, I think, what David's given you is the procedural history and the posture of the matters up to date.
I'd like to ask a question, if I might. Could you explain to me why from 2003 to now the city has not given this a designation? What is the reasoning behind that?
They might know how to answer that.
Yeah,
It
let
might
me-
we could be back in litigation.
Yeah, let me respond to that. With all due respect, I'll answer that question when all the litigation is over. Because anything I say right now, if the settlement agreement blows up, can be used against the city.
Yeah, but it's very, it's
That's
quite
a fair
relevant.
question. That's one of our
It's
questions,
what-
but I don't think they want to answer it.
It's quite relevant. In the application here, the engineering firm, on at least 2 separate reports, indicated that the reason that they're asking for the extension of the area you can mine in, the reason is because the city, since 2013, this is the language that's in the engineering report, has dilly-dallied. They wouldn't give them an answer as to what they could do with their property. And that's the reason we're here. So says the engineering report. So now, if that's been resolved, at least tentatively, and the city has agreed to give them a designation, and indeed has agreed, subject to zoning, of course, that they can put in the residential units that they were seeking all this time, why are we here? Isn't the need for this hearing obviated?
So let me answer the question in a way that I think will make sense. While the city council entered into a settlement agreement, and this is evidenced by the recent settlement and the resolution of the WCI matter, the city still has to go through the process, and the city council still reserves the discretion to consider those amendments and rezonings as standalone items. And if they choose, through the quasi-judicial and legislative process, to deny them, nothing in the settlement agreement forces those changes. It is your job to look at the application on this application today, on its merits. It'll be the city council's obligation to look at the IPD and the future RPD and the comp plan amendments on their own merits. If they do not approve them, it will have consequences for the settlement agreement, but they are to consider them based on the criteria set out by state law and by the city's codes. And so it's not as simple as to say, well, there's a contract in place under the settlement agreement and they have to do these things. There's a procedure for how they will hear them, but if the outcomes are not in line with the settlement agreement, that agreement provides for that.
But this is aside from the agreement. There's a rationale offered in the documents here, the engineering reports in particular, that says the reason that we need this expanded area to mine is because the city has refused to give us a future land use designation or whatever,
And as of today, it still has not.
as of today. But there's a settlement agreement to do just that.
Correct, but as I stated, it may still not occur.
Okay?
Unless there's any other procedural questions about how this matter came to you, I'd like to swear in the witnesses to go forward on the actual application.
Yeah, I
Please.
just want to add one thing to what Derek said. At one point in time, he said, we're under the city regulations. The RPD will be under city regulations and comp plan. This application is still under the county's regulations.
Correct.
That's
And obviously, I know there's, why not wait? Property was annexed in 2003 pursuant to an annexation agreement where there was a commitment that the city was going to change the comp plan within 18 months. We're a little, to your point, past 2003, so I think it's essential to the property owner that they be assured they have a reasonable use of the land, which is why we're here today.
So do I read that you want this because if the city does not go through with whatever they have promised in March, you would continue to mine this property? And do I also understand, as I look at this, that if you don't get this expanded area, there isn't enough left to mine to keep you going to 2041? Is that an accurate?
Well, I think that's probably a question better served for actually during the hearing once we've
Right.
Okay,
sworn in, because
all right.
it's a factual.
And Mr. Chairman, let me just add one other point. What was it, did we end it at 750?
700.
700. One of the reasons that there were extensive delays, for lack of a better word, is the applicant was seeking over 2,000 units. The settlement agreement landed at 700. The city's initial position would have been somewhere south of that because this was a negotiation. So to the extent that there were some delays associated with coming up with a comp plan designation for the property, in large part, it was the difference in the number of units that the property owner wanted versus what the city wanted out there, at least during my tenure. I can't speak to what took place prior to me becoming involved with the city. And through the settlement process, the city and the applicant were able to reach a number that was acceptable to both parties. So that's why we were able to enter into the settlement agreement. Now, that may or may not happen, as Derek indicated. This approval was a threshold issue in the settlement agreement. The next step is to hold a hearing on the comprehensive plan text amendment. We actually created a new land use category for this property. The city council has to approve that, and that has to go to the state. There are statutory requirements for that. And then after that process is completed, we also have the PD zoning to implement the residential. At any point in that stage, in that process, if the city council says no, then the settlement agreement blows up. We're back in litigation, and I think the applicant wanted the assurance that they at least had the mining rights locked down in case it did blow up. So that's why the process is set up rather than running them concurrently or getting a city designation first and then bringing it in. And that was all negotiated. The time frames were very important to the applicant, and the city council agreed with those timeframes.
Can I ask one other question? Is, when a settlement agreement is negotiated like this, does the staff or your attorney sign off on it, or does the council have to sign off on it as well? I mean, ordinarily, it would be the party that would have to, but
We
I don't
may-
know about government situations, so.
Yes, we, as a staff, we made a recommendation to the city council after mediation. We had a city council member attend the mediation, and the city council member can't bind the city. The proposed settlement agreement must go to the city council for final approval.
Has it?
Yes,
And the council has approved it?
yes.
Yeah, and we didn't get to go, but they had several, what they call shade sessions with the council as we moved through the process. So they were in communication with the council until, up to and including the time it was negotiated.
Yes.
Is there anything further? It's the applicant's,
Are there any other questions about process and how we got here? Okay, then,
Okay. All witnesses, or anyone intending to give any testimony, please raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
okay.
our first witness is Dr. David Depew. Mr. Depew's been accepted both in court proceedings, DOLA proceedings, and in zoning hearings as an expert in land use and planning. And we'd ask that he be still accepted here today.
No objection.
And I would note before he starts that he's also had extensive experience in applications relative to natural resource extraction for what, 20-plus years?
Unfortunately, it's been more like 30-plus.
I know, I'm trying to be nice.
I would love if it was only 20-plus years. Unfortunately, it's been 30. I'm, just for those of you, and I know that Mr. Inserpi knows me, but those of you who don't know me, my name is David Depew. I'm here on behalf of BG Mine. I am a principal with Morris Depew Associates. I'm a former community development director for Lee County back in the prehistoric days, early 80s, and have been president and principal of Morris Depew Associates since its inception in 1989. My practice is in land use planning, and my practice is statewide, although the primary office for Morris Depew is here in Fort Myers in the Lee County area. We also have offices in Tallahassee and in Destin. You see before you the team that has been working on the current request. We have a broad array of expertise, including legal expertise. We have Tina Ekblad here from Morris Depew as well. She's the planning director for the firm. And we have other folks that are part of this team that have prepared the documents that are part of the application that is before you today. As you're aware, there's a long history with the subject property. It's located in the northeast corner of the city at the end of Bonita Grand Drive. Property is east of Belle Villa and Citrus Park. It's north of East Terry Street. The green dotted line that you see on the, here we are, green dotted line that you see is the city boundary.
You see a green dotted line?
There's a green line. You see a green line?
You see the green line?
I don't see a dotted line.
Well, it doesn't show up very well, but it's actually kind of dotted. It's a hash pattern. It just doesn't show up very well on that.
Everything in green.
Okay, okay. Thank you.
It's right, it's that line there, and it corners around the edge. The red line is the property boundary, and you see the little jags along in here. And when you get a slightly higher resolution, I promise it's dotted. US 41 is on the extreme left side of this slide. You can see it's mentioned, it's labeled over here. You've got Old 41 as it goes through, I-75 as it comes up. Bonita Beach Road is here, Bonita Grand Drive heads up and ultimately accesses the mine. Just to give you an idea of the actual location of the mine itself. It's, as I said, located on Bonita Grand Drive. You can see the excavation lakes here on the subject property. There's the northerly lake. And you see there a darker green than the southerly lake, which is a lighter green, which means there hasn't been a lot of excavation recently in those two lakes when this picture was taken. Where you see the lighter green area, that means there's activity, excavation activity taking place in the lake. What happens as the excavation occurs is the silty material gets mixed into the water, and it takes a little while for that to settle out. So if you see the lake that's kind of that, I want to say, a kind of a jade color, that light green, that means there's been excavation activity. Where it's a darker green, such as these lakes up here to the north, that means those lakes have not had excavation activity in a while, and the silt has actually dropped to the bottom of the lake, and that's why they have a different color. To the north of the property, you can see the area that is in the county. It has recently been acquired by Lee County. It is designated as DRGR. That is what is known as the Edison Farms property up there. And the county has just recently acquired that and is intending to list that as a preservation area ultimately. Similarly, the property to the east and southeast are designated DRGR by the county's designation, and they're part of the Corkscrew Regional Ecologic Watershed. So on at least two sides, or 2.5 sides if you consider the southeast, the area has been preserved, and some of that preservation actually stretches onto the mine property itself. I'll get into that more in just a minute. To the west is Citrus Park and Bellevilla. You can see those very clearly on the slide before you. And beyond those two developments to the west is the Bonita Springs Utilities Facility, Liberty Youth Ranch, and to the northeast are agricultural and additional resource protection
Before you
land.
proceed, I know this council hasn't had a lot of experience, any experience with a Lee County DRGR, and so they may not know how or why it was created. So, it is my understanding that it was a result of a settlement agreement with what was then the Department of Community Affairs.
That's correct. At the time, Lee County had what was called a privately funded infrastructure overlay for development outside of the urban service area. The department at that time didn't like that particular option and felt that it did not adequately address concurrency concerns, and as a result challenged a plan that Lee County had adopted that implemented those regulations. And ultimately the settlement for that challenge adopted a new category, which was the density reduction groundwater recharge or groundwater resources category. And it limited density in those areas to 1 unit per 10 acres, as well as establishing certain uses that are allowed in those areas, one of which was included was mineral resources extraction as a potential use. But the idea was to limit the activities in terms of allowing urban activities to take place in these particular areas of the county. Mining, despite what you might think about it, while it's an intense use, is generally deemed not to be an urban activity, but rather an activity that's taking place in rural areas because of the need for establishment of large buffer areas and setbacks in order to improve compatibility. So what happens in the DRGR is you find a great deal of concern with regard to compatibility and setbacks for some of these resource extraction operations. And the mine was no exception. In 2003, when it was 2002 and 2003, when the county rendered its final approval on the mine, there was some concern about compatibility, and that was addressed as part of the hearing at that time. Bonita Grand Aggregate Mine supplies Southwest Florida with lime rock materials and is part of the overall regional demand. The subject property was identified as one of the elements for providing lime rock resources and natural resources to Lee County and to the region in the 2008 analysis that the county authorized by Dover Cole and Associates. And ultimately, that was updated in 2016 by Waldrop Engineering in their revision and upgrades of the reports that were done under the Dover Coal study. Although it is technically within the city, it was nevertheless included on the county's, in the county's comprehensive plan and map 14 of the Lee plan, which recognize these areas as those being most appropriate for location of lime rock mines within Lee County. And we think that part of the reason it was done in that fashion is that it still was under the county's jurisdiction and is today still under the county regulations, which is why you're being asked to review this in terms of what the 2003 regulations were. And for the new member of the zoning board, I think this is pretty unique. I suspect you're not going to get too many of these kinds of cases for you. They're not usually quite this complicated. This is a list of the permits that Bonita Grand Mine has gotten over the years. Now, I'm not going to go into this. I just wanted you to know that this is a very highly regulated business. It is one that has been going through the permitting process and continues to go through the permitting process over the years and has a lot of different government agencies that review it. In terms of the history of the mine, as I noted, it's long, it's detailed. The site is 1,268 acres more or less in size, of which there are approximately 370 acres designated for conservation and under conservation easements. Those areas are primarily located along the easterly side of the subject property, but there are areas internal to the subject property that also have conservation easements placed on them. There are just under 400 acres of mine lakes on the property at the current time. Current property and the current future land use designation remains Lee County's density reduction groundwater resources, as that category was never defined, as that category was defined in 2003 when the annexation took place. That future land use category allows natural resource extraction, mining as a permissible use. Mining on the subject property was first approved in 1987 on the southern portion of the site. And in 1998, Resolution Z-98-071 extended that mine footprint to the entirety of the 1,268 acres. Resolution Z-2-47, which I believe all of these are in your packet, which I know was extensive, permitted the current operation to a depth of 90 feet or the confining layer, whichever occurs first. I'll talk a little bit more about that in just a minute. It added uses to the mining operations. The settlement agreement with the city under which this request is moving forward extends that date into 2041, which you already heard. There are environmental permits that were first issued in 1991, will expire in 2041. The reclamation is not the least of those permits, but there are others, and that is the primary permit that we're talking about that expires in 2041.
But under Resolution Z-98-071, that limited the mine life to 20 years, did it not?
It did, and the 2002 resolution once again reaffirmed that. The mine itself, over the period of time with Bonita Springs, has gone through a series of extensions due to the executive orders of the governor. Every time the governor establishes an emergency time frame, whether it be through Lake Okeechobee discharges, hurricanes, I believe there was a Zika virus emergency, the legislation establishes the ability for any particular operation, of which the mine is one, to extend the life of their permit. And the mine took advantage of those permit extensions starting in 2000, I want to say 7 or 8, when they first started granting those things. Because the 2003 changes that it thought were going to take place did not take place. So what happened is the mine took advantage of the statutory ability to extend the sunset date on its permit, and those were granted to the point where I believe it's now up to 2034 is where.
2035, I think it is.
Something like that, yes, sir.
So there's a Zika virus or a
How
series
about
of
opiates? There's another one.
Yeah, there was an opiate.
Opioid
one.
ones. They have a lot to
crisis,
do with
and you can extend the life of the mine 17 years.
Yes, sir.
Well, yeah, and just so you know, last year the legislature changed this, so now it has to be a natural occurrence, so it has to be a flood or hurricane, something like that. It can't be Zika or opioids anymore.
But it can often be a fire in the panhandle.
Okay, so here's my question.
Well, no, they changed that to, it has to be actually applied to your county.
Go ahead.
So you're saying that an executive order that declares an emergency can be used to change basically local regulations, local agreements that were reached without any logical or connection between the emergency and your ability to do what you're doing, like extract minerals. So ordinarily, one would think an emergency would give you an extension if somehow that emergency had some effect on your business, so you couldn't produce at the level that you were supposed to. And I guess I'm a little bit surprised, but then I didn't know about this, that unilateral action by an executive actor, the governor, can undercut what are basically agreements locally and statewide that set up limits on various activities like yours. I mean, there are all kinds of things that are used this. But now you're telling me that in the future, the legislature has acted to say there has to be some connection between the emergency and what you do?
No, the change last year just said it had to be a natural occurrence. It couldn't be like Zika. I will say this, one of your conditions in here says that the expiration date is 2041, and we'd have to come back and amend it. So by virtue of the settlement agreement, we can't continue to file, because in theory,
You'll go on forever.
yes.
Yeah, but here, let me follow up on that, because I need you to help me think this through, because I'm confused. In 2003, there's a new permit. It's about the time that the city annexes the property. In 2009, the city challenges the mine for failing to comply with all the conditions that were placed on it. So a period of 6 years, there appears to be no compliance whatsoever. Then the city comes along and enters into an agreement. They enter into, the mine and the city, community development, enter into a binding contract saying this mine will cease operations on December 31st, 2018. I think somehow that gets extended to 2020, if I have my facts correct. But in any event, the agreement says that. Are you saying that people of sound mind can enter into a contract with one another, a binding contract, and some external force, the state, can come along and say, we're overruling what you want to do?
They did.
They have the right to do that? Show me a case, one of you. Please, show me something. That doesn't make any sense to me.
There is a statutory provision that expressly authorizes the governor to enter or issue executive orders. And
Right.
if the governor does so and your county is subject to that executive order, there is an automatic extension. It's not even...
I get that, but there was an intervening act here. Prior to the time, these executive orders started to come down, I think, in 2007. 2009 comes along, the city and the mine enter into an agreement. That's different than what you're saying, Mr. Theriot.
Let me,
Here, there's a written contract.
Well, if you're talking about the annexation agreement, we're trying not to go there because our opinion is that the city.
no, I don't think he's going into the compliance.
Or are you talking about the
He's
amendment?
talking about the compliance agreement.
Okay, that agreement.
The compliance agreement, that's right.
So sort of answer both Member Craig and the chair's question. It's not just the executive, it's the legislature set up the process. And there are conditions to it. So a property cannot be in significant violation of regulations. It can't, basically it can't bring life into a project that is failed for other reasons. So there are some conditions to the approval, but the concept was originally building permits and all development orders as that's defined by state law, which includes rezonings and environmental permits. What the city's 2009 compliance agreement said is it said you are not in violation, you are in violation, and the city uses code enforcement powers, of your existing Lee County approvals. And it recited those approvals. And I get your point, which is, well, the compliance agreement is binding and it's not a development order. But the compliance agreement is instituting compliance with the development order, and the underlying development order has been extended. And therefore, yeah, so, but to your point, I think what is clear is our settlement agreement puts a deadline on the mining activities, and that is binding.
But Mr. Rooney, that compliance agreement specifically said that this shall be binding on the heirs assigns, and it shall run with the land.
But that compliance agreement cannot extend beyond the authority of the city in its local regulatory powers. And its local regulatory powers are bound to those development orders,
But
which is the underlying.
don't you look at the
approval.
powers that existed at the time
Well,
that the agreement was entered into, not some future thing? By that logic, any agreement that's entered into is really not a valid agreement, because we could change our minds at any time, or we could be overruled by somebody.
the city and the state
That's your-
have the right as legislatures to extend their authorizations to go further, to forward. And so I don't remember exactly when that state statute was put in place, but even that at 2009 it was in place.
Yes.
So any agreement would be subject to notice.
Does the statute...
That is subject to that
Does
statute.
that statute say anywhere in it that this supersedes agreements made by willing parties, and any contracts you enter into are subject to this? I don't think it does.
It doesn't do that, but I
Doesn't.
would say what it does do, and it followed a series of things. Just kind of go back in time, and David and Derek can speak to this, but when the recession happened, the legislature adopted a series of legislative extensions of development permits. At first, it was a 2-year, there was a 4-year, there was an ongoing series, and somewhere during that time frame, I think it's 252, I don't remember what point what, but yeah, it makes it clear that the local government doesn't have authority to not allow those extensions. I mean, essentially what an applicant does is sends the city or the county notice that says, we're gonna ask for this time under the statute, and as long as the very few criteria are met, the city
Have
can't
there been
say
any
no.
cases decided on the question that I'm raising?
There have been some cases under that statute with respect to notice and filing, whether or not there was affirmative actions, under what conditions the local governments can reject
been
it,
a
but not
case
under
that
that, not under that I'm aware of. And I can,
So there's not, we're kind of in interesting territory here. I believe we should follow the law, and whether I agree with it or not doesn't matter. It's the law is the law. But here, we're saying the law, you enter into a legally binding contract, it's not really the law. Because there's somewhere out there's another law that somehow supersedes this, but nowhere in that law that you're citing, does it say this shall supersede any agreements.
Well, it's kind of like the feds can tell the states what to do, and the states can tell the local governments what to do. Sometimes that happens.
Okay, please continue.
All right, moving on, I'm going to skip the rest of my presentation on this slide because you all pretty much already hashed that through. As I noted, the current process is pursuant to the 2003 County's Comprehensive Plan and Land Development Code. This is because the Florida statutes control what happens to land after it's annexed into a municipality. And although the current plan amendment request has actually been pending since 2013, it's not been acted upon. And as a result, the county regulations, including prior approvals, remain in effect. The section of the statute is actually quoted there on the screen that applies for it. The request before you today will increase the size of the excavation by approximately 299 acres. It acknowledges the new expiration dates of the mine operations, an expiration date that, as I understand the settlement agreement, we cannot request, the mine cannot request any more extensions of, so that 2141 date is a final date. It will bring consistency between the city and the FDEP permits. No changes to the existing conditions are being proposed, and the operations remain consistent with the applicable Lee County regulations. The most recent FDEP approval, which was 2018, is consistent with the request before the zoning board today, and all the conditions of Z02-047, except for the excavation area, will remain in full force and effect. Traffic volumes remain unchanged. No new traffic is being added to the road network as a result of the request. Project phasing and reclamation remains unchanged other than the completion date. The request is intended to help meet the regional demand for growth that is the result of the growing population across Southwest Florida. This aerial photograph shows the current conditions at the mine. You remember the prior aerial photograph, I said that the lake color was significant, and again, you can see in this one, and north is to the left of the screen in this one to make it blow up properly given the aspect ratio on the screen before you. You can see that the central lake has not had much in the way of activity, and even this southeasterly lake is starting to settle down, but there has been activity in the southwesterly lake as well as in the northerly lake. You can tell that, as I said, from the color, which is roughly the color of the decor in here.
Are the areas in the light-colored areas, is that the internal roadways?
Yes, sir.
All
Those,
the internal roadways shown on there?
they are, and you can see classically the roadways, which are these long kind of straight elements. And what you see around the lakes themselves are the collar, which are the working face of the mine itself. So for this southwesterly lake, this is the working face that's currently being worked on. And this was a working face here, but you can see it's starting to go back to a more, I won't say native state, but a less disturbed state in this area here. Similarly, on this northerly lake, you can see the working face along the southerly side of the lake, whereas over in here, there hasn't been much in the way of equipment. So the white surrounding the lake areas are areas where the drag lines or the trucks or whatever have been working around the face of the lake. You can see the surface of the lake changing as it works on it.
Excuse me, where's Bonita Ground Road on
It
there?
is
That
right
down on
along the bottom of the slide there.
So that's Citrus Park on the north, or above?
To the bottom would be Citrus Park. Down here and off the slide is Bellevilla. Okay, so if you go to the lower right-hand portion of the slide and go off the screen, you'll see that's where Citrus Park is. This is the actual entrance to the mine. Here's the operations area, the scale and the offices and everything. Up here is the area where the sorting, crushing, and the rest of the activity is taking place.
Mr. DePew, as long as we're on that slide, Mr. Theriak mentioned that a portion of the property would ultimately become a park for the city. Can you identify that location for us?
That area is up along the northerly portion of the property, up in this area here. You know, in addition, this hatch area here, it's kind of a dark dotted pattern across here. That's the conservation area. And you can see there's some other dotted patterns interior. Those are also the conservation areas. And so the area that the city would end up getting as a park is this area around this northerly lake up in the north end of the site.
To that point, is there, other than the roadways, is there a way that could be donated, sold, given to the city?
Well, that's what's going to happen as part of the settlement agreement.
Okay. Prior to the 1941 or 2041.
If the balance of the settlement agreement is approved, that's what will happen. But as the attorneys explained, what's before you today is basically the property owner's insurance. Not that we don't trust the city, because we always trust our elected officials. But the original agreement was struck in 2003, and it's now 2019, and admittedly there have been some ownership changes over the years. The mine went through bankruptcy and foreclosure and reacquisition, but nevertheless, the history from 2003 to the current has been, shall we say, rocky. So what everyone's trying to do is make sure that there's nothing left to doubt.
Can I ask a question here? Because you raised this, then in this new agreement, supposedly, you cannot ask for any other extensions. So if the governor declares an emergency that allows an extension, does that mean that somehow this settlement agreement, which the last settlement agreement apparently was not able to do, can tie your hands so that you will not ask for more extensions?
That is the intent of the settlement agreement, that the applicant waives the right to make the request. The governor issues these executive orders, and then within a certain number of days, a property owner or a developer must submit a letter to the local government saying, pursuant to the statute, we are taking advantage of the extension of time. They have waived that ability in this settlement agreement. So if the governor issues 3 more executive orders for hurricanes and extends timeframes out, they have waived the ability to make that request.
So they have the right to waive, but they don't have a right to contract when the mine terminates.
Now, that's the point I was trying to get
Well,
to.
Wait,
I'm going to be clear on this. I'm looking at the compliance agreement now. I don't see a deadline anywhere in it that isn't just tied to the original development order.
Yeah, to the 218.
Right, and the other part of it is, it specifically provides that it can be superseded by an agreement of equal formality. So a settlement agreement with the city council would overrule any provisions in this agreement.
That makes sense to me.
So, I mean, I just want to make,
But that's different than,
City council.
that's different than someone imposing their will.
right. So there's
Parties have-
nothing
What
incompatible.
you're saying is the parties have a right
So you're,
to agree to supersede that. That
Right.
so
makes
you're saying
eminent
that's
good
an
sense.
enforceable provision of this settlement agreement, that even if the governor were to issue another emergency thing because there are too many mosquitoes around, or whatever, it seems to be about that level, that they couldn't take advantage of that and get 5 years more, assuming they went on.
We would have a right, the city would have a right of specific performance to prevent them from doing so.
And you go to court to do.
Right.
Yeah, and if you, obviously, you know, in the proposed condition 2 in your staff report says if we were going to go past that timeframe, we'd have to come back through the process for a public hearing.
Go ahead. Yes, please.
So it could.
The site's been studied rather extensively from the standpoint of subsurface conditions, as you might expect from the picture that I showed you. There are essentially 9 various geologic strata that exist in varying quantities on the site, across the site. The mineable lime rock material ranges from between 10 to 108 feet below land surface, with a confining layer of clay below the lower layer of mineable limestone. That confining layer ranges between 30 and 32 feet in width. And you can see a description on the slide of each of the 9 strata that talks about what the characteristics are, with the confining layer at the bottom between 30 and 32 feet in depth. That clay layer on the bottom is one that the miners attempt to stay out of. It contaminates the aggregate coming out of there. It makes the aggregate unusable without significant washing, which makes more expense. So the restrictions on it is 10 feet above, or the confining layer, well, the 90 feet or the confining layer, whichever comes first, so that confining layer will not be penetrated. And it's not in anybody's interest to penetrate the confining layer. The geologic reports show mineable rock can be found in varying depths across the site. Those depths change depending where on the site you are. I mean, it's a 2-mile site from north to south. It's part of the current applicable conditions that limit the mine depth as to the actual width of the mineable lime rock. Because the layer depths are variable across the site, as I noted, if the confining clay layer is encountered at a depth of less than 90 feet, that it stops. If it doesn't get encountered before the 90 feet, the 90 feet of the maximum excavation is the lower limit of the mine. Under no circumstances is the clay layer to be penetrated, and that will maintain the hydraulically significant confining layer that forms a pan, basically, underneath this mine. In terms of the traffic analysis, the mining operation itself is not a new operation, but rather taking advantage of the full range of the resource that exists on the subject property. To that end, no additional AM or PM peak hour trips are being added to the network. The trips from the mine are already included in the city's traffic count report as background traffic currently because it's been in operation for such a long time. Both Bonita Grand Drive and East Terry Street currently operate at level of service D are within the adopted level of service specified by the comprehensive plan. As was seen in the aerial photograph of the current conditions, the jurisdictional wetlands on the subject property have been delineated, are being preserved. They have been placed into conservation easements, and the mine operators are maintaining them free of exotic vegetation. The perimeter berm that separates the mine from the preserve area to the east is complete and is shown on the master concept plan. There are no changes to any of the preservation areas proposed in this amendment. Further, the monitoring wells that are required by the current resolution Z-02-47 are in place. The monitoring is ongoing. The MCP depicts the locations and those are not proposed to change. The site is designed to retain all the stormwater on the property.
Could you stop for a second? Let's talk about the monitoring wells for a second. Who monitors the monitoring wells?
The monitoring data are collected depending on the well on a monthly, quarterly, and annual bases. They're forwarded to the Lee County Division of Natural Resources, and they are included in their annual reports. They are available, though, depending on, again, the monitoring, on a monthly and quarterly basis from the Lee County Department of Natural Resources.
Is there a kind of an overview of what's contained in those reports?
There is, I believe, an annual report that gets issued on them, yes, sir.
And have those shown any issues?
So far, they have not. Again, there's way too much text on that slide. I'm not going to try and go through them. Those are some of the conditions under the current zoning approval: maintenance of machinery, blockage of noise generators and mufflers, driver education training regarding routes to and from the mine, physical speed control facilities on Bonita Grand Drive. If you've driven up there, you can see the speed tables which slow those trucks down. There are signs on Bonita Grand Mine for the truck drivers telling them not to take East Terry Street, and the ongoing monitoring are all features that are found in the existing conditions.
But ask something about the monitoring of the truck traffic and where it goes. Do we have any data as to whether there have been any reports made of trucks using East Terry, or there have been any enforcement by the Sheriff's Department against trucks using Terry Street?
I will tell you that from my experience, there is not a lot of monitoring data on what trucks use East Terry. The reason being that the trucks themselves generally are independent operators, and they're frankly legally permitted to use any public roadway just as anyone else. We try, as part of the mine operations, to tell them that this is not being a good neighbor. We give them education both in English and in Spanish, asking them to use Bonita Grand going down to Bonita Beach Road and not to use East Terry Street. But candidly, it's not illegal for those trucks to use East Terry. So all we can do is encourage them, request them not to do that, suggest that this is not a good neighbor policy, tell them that they're going to run into problems if they continue to do this, and that's really the best we can do, because as a mine, we don't have enforcement operation and monitoring operation.
In these pamphlets that say that you will, if this is a problem, notify both the city of Bonita Springs, although I think it actually, in the old one said Lee County, and the sheriffs of Lee counties, that would not be something that you would do because you don't think that this... We
could do it. I mean, the question is, how is the sheriff going to stop them from using East Terry? It's not illegal for those trucks to use that road.
Vacuous.
Well, Ms. Craig, what I'll point out, one thing that in the settlement discussions with regards to this, to the broader case here, And unfortunately, the individual, the Public Works Director, Matt Feeney, is not here. But I had conversations with Mr. Feeney about condition of Terry Street, traffic studies the cities has done on Terry Street. Never did he raise a concern, although that the impacts of the residential development would have an impact on Terry Street because he knew that people would use that to get downtown. Never was a concern raised about the truck traffic or other issues. And I would assume that when the city conducted those studies on the actual traffic counts, that they would have realized and had some awareness if there was an issue.
How many trucks on an average day enter and leave the property?
Couple hundred.
So-
You know, there is a proviso that you can create a no-truck route roadway.
Yeah,
It's
that
a
would-
legal statutory ability to do that, and if the city decides they want to do that, they could conceivably do that.
But as I said, I have heard no indication
And
from
there's
city
been
staff
no
that there's an
complaints
existing
from
issue.
people who live along Terry Street that that's a problem?
On the record, Jackie.
Good morning. For the record, Jacqueline Genson. Previously, I would say it's been several years, we used to receive complaints that trucks were using East Terry Street, and we did have the ability to coordinate with the applicant's agent and the mine operator to get a better handle on that. But I have not received complaints, again, in a couple of years.
On that subject, what is the final destination of your product? Usually, is it Collier County? Is it Lee County?
It goes all over Southwest Florida. It's primarily in Lee, but there is to some extent in Collier as well.
So where does it go when it gets to the intersection? Because we're talking about traffic here. One of my concerns, of course, is the intersection of Interstate 75 and Bonita Beach Road, and the fact that it's already overcrowded with traffic and throwing more traffic at it is, going forward as the city continues to grow, is a concern. It should be a concern to all of the citizens.
That's where most of the traffic goes. It hits that interchange. But remember, this
Go
traffic
north and
has
south
been-
from there.
Goes north and south from there. But this traffic has been on that roadway since the 1980s. This is part of the background
I
traffic.
understand that, but of course, as we continue to grow, and that's, we're talking about going to a couple of decades out here on the continued mining. And as we grow, we're going to be growing vertically, not horizontally. And that's just been a concern as I read through all this documentation about the additional traffic flow that's going to be forthcoming.
Just
Let
to
me
put
follow
it
up.
in, well, let me also just add in terms of context here. At a minimum, 80% of everything you see built here is made from aggregate. At a maximum, it's going up to 93%. Roadway, for example, construction is somewhere between 90 and 93% aggregate. So all of this is going to depend on the mine or other mines like it. You're better off having those things closer rather than further away, because that means those trucks have less time on the road and less impact to the other traffic. So if they've got to come from State Road 82 and come all the way around down to Bonita where it's growing, as opposed to from Bonita Grand Mine to where Bonita's growing, those trucks are going to be on the traffic a whole lot longer and interfere with traffic a whole lot more than they would be if they were closer.
Well, let me give you an example. Bonita National is an ongoing development. If you didn't have this mine, would there still be trucks at the intersection of Bonita Beach Road and 75 coming from some other further away destination?
No question.
In other words, when you ask about where the destination is wherever development's occurring. Right now in the city, Bonita National and out east is where a lot of it's occurring. You're kind of running out of locations, so it may be going to Collier, but I think Bonita Beach Road is going to be your corridor for a while where it's going to go. So it may not go through the interstate, it may just go east, but the answer is it's going to go where development's occurring.
The other thing I'd add is the cost of transport of this material is a significant portion of the cost of construction. And so as a result, every time you add extra miles for transport, you're going to add cost. So that means everything's going to cost more. All the houses are going to cost more. The roads are going to cost more to build. And it means affordable housing is going to be less and less affordable because the cost of these things increases as a result of the scarcity of the resource and the fact that you've got to transport this resource. I mean, I've been in lots of hearings where I've been told, oh, we're just going to get everything from the Bahamas or we're going to get everything from Mexico. That's less than 5% of the aggregate demand, according to the studies, less than 5%. But that's just not a viable option. And even there, your aggregate is either coming from the East Coast, which there's a heck of a demand over there for it, or it's coming from Port Manatee, which is another long trek down here. And you can see what's going to happen. The cost of these things is going to grow and grow and grow. I mean, okay, it's nice to be able to say, we don't want a mine. We don't want any of this stuff done because it's not a pleasant process. But it's just like any of the other things that come with urban life. I mean, you know, wastewater treatment and solid waste control and all these sorts of things. You still have to have it. You have to provide for something like this. And this is a critical resource that we actually have in great supply in Lee County. Some places don't have this, and as a result, the costs go up. That may be more than you wanted to hear, but the
Strike me as a very strong argument to keep this a mine and not a development, however.
I didn't hear the hint.
I said, it strikes me as a very strong argument to keep this operating as a mine, to keep housing prices down and road prices down, rather than to have it move to a development. Just,
Well, I think, and perhaps the applicant will address this, but while the permitted lifespan may be 2040 something, you know, if market conditions remain similar, I don't think the actual lifespan of this mine will continue much longer. I mean, there's only so much, they can't dig when there's no
well,
land.
that makes this sort of,
Your personal opinion.
That's my
Are we
opinion.
doing
That's why I'm
this?
going to ask to see if the applicant has anything
that's
to add to that.
correct. I mean, and the simple fact is that the Easy Rock is starting to more or less, and you saw the picture. Let me pull this up here on the paper.
Does a mine play out?
the only thing about this that makes any sense is
You can see the mine. That's what it looks like at this point. I mean, the Easy Rock is gone. I mean, there's still rock there, and we can still mine at the current rate for at least another decade, maybe a little bit longer without too much trouble. Now, if the market turns down like it did in 2010 again, then who knows? It may get stretched out further. But the operators of this mine, when they bought the property out of the receivership, we're happy to have this thing because it is generating money. I mean, it's a resource that's out there. But the idea was always to evolve this into some sort of residential community. In fact, back in 2003, that was the idea, to evolve this into a residential community and to use the resource as best as could be done to assist in doing that as well. So yes, the resource is there. Can we continue to mine? Yes, we can. But that's really not the business these folks are in. They're much more into developing as residential. And we have other mines that are now starting to come online in Lee County. Florida Rock Mine number 2 is an enormous mine off State Road 82. The Troyer mine just got approved as well, which is another 700 to 800 acres of excavation, which is again off of State Route 82. So the resource is still available, and it's available in an area which it's easier to mine. I mean, quite candidly, it's easier to mine than actually coming back out here and deepening some of these lakes down to the 90-foot level. This is probably way more than you want to do, but the way these mines operate, it's very market-driven. They have certain classes of aggregate that are produced and certain classes that are extracted, and you don't exactly know what you got until the bucket comes up with the load of aggregate. It goes to the crusher and it gets sorted and everything. And the stuff that is in demand at the time gets sold literally right out of the stack. But they don't have a lot of room to store the stuff that's not being sold. So that gets pushed back into the pit. And when that market comes back, and there's a demand for the stuff that's pushed back in the pit, that gets re-excavated, gets sorted, screened, crushed, and then gets shipped off-site. So there's a continual give and take in the excavation operation. So and that's partly why these lakes get sort of silty, because there's stuff that goes in, there's stuff that comes out, depending on what the market is. Now, that's what these folks are doing at the moment out there. They're taking in and out of the mine stuff that is in demand. So if they get an FDOT contract and they need certain FDOT spec rock, boy, that's going to come out. Most of that's still in place, so that comes out, and that's one of the most expensive aggregates that you can produce. So that comes out, and that's a great contract. But if you're just using simple base rock, that doesn't have to be to that specification of hardness, size, and density, and all these other things. So that comes out, and if it's not available, it's been put back in the mine. That comes back out and gets reprocessed and gets sent out. That's at a lower level. But yes, the mine is a resource. It's something you would like to keep, but on the other hand, it's like by the time this all gets in place and the development moves forward, there's not going to be that much left. As Derek says, there's not a lot. This is not like it's a virgin site anymore. It's been excavated for years, since the late 80s.
You've talked extensively about the mining operation. I don't remember you mentioning the processing operations. Can you show us and describe for us what the processing operations are?
This is the area right here. What typically happens is the rock is pulled out of the pit. It goes into a field crusher to get it into something that's actually transportable, because they'll come out in very large boulders, as you might imagine. The bucket size, I don't remember the exact bucket size in terms of how many yards comes up per pull on the excavator in this thing, but it's a lot. It's like a dump truck worth of rock that comes up. And not all of it is to the right size. In fact, none of it's to the right size, basically. It comes up in large areas. So it goes into a field crusher so that
Where is the field crusher?
it's right on the edge of the,
Can you show us where, please?
it's wherever the excavation's taking place. So if the excavation's taking place here, the field crushers will be alongside so that the boom can just swing it over into a they call them windrows. They're just big rows of excavation. And the field crusher's next to the windrow. It dumps it in there. It then goes on a conveyor up into the back of one of the trucks that transports it over to the
So
processing
these
plant.
conveyors and the crushing operation is a mobile operation,
Yes, sir.
and it moves all around where the mining is taking
Correct.
place.
It then goes to
Are
the
there any other
processing
crushing
plant.
operations on the property?
I'm sorry?
Are there any other crushing
Yes, sir.
operations?
That's what I was going to say. It then goes back to the processing plant. At the processing
Where
plant.
is the processing plant?
That's that area right in the middle with all these little circles.
And in the
So if they're
processing,
here, it gets transported. They're here, it gets transported back over to
so
here.
the conveyor belts in the field processing, those are outdoor?
Yes, sir.
Are they covered in any way?
The field crushers are covered and muffled. Okay, and they're also back off the property line, and they're typically behind the windrow of excavated material.
And then,
It then gets transported over to the main processing area.
and there are, and you further crush it in the main area?
Correct, and that's enclosed. All right? It goes onto conveyors, it goes into the crusher. It then goes into what's called it's basically a sieve, and it gets sorted out into different sizes, so that you get the very small pieces and the larger pieces, and it's all depending on, it's called a screen house or screening room, and they screen out the different sizes of aggregate. And then they go into piles, depending on their size, and you can see little circles of piles. And those are where the inventory is, and those then get loaded up into trucks that ultimately go to the scales and then take the material off to whatever job site.
Could you tell us what dust mitigation efforts
Okay.
made at the mobile crushing plant and in the indoor crushing plant?
Sure, they basically have everything wet. Everything gets soaked so that the dust settles down and the wash goes off into the pit itself. Materials that get washed off the rock are called fines, or fine sediment. They just refer to them as fines. And so they end up getting washed back into the mine pit itself. And that's where the primary dust control is. They also have some fugitive particulate controls on the crusher. The exhaust, things like that, has filters on it. Also, the site gets a watering.
Are those filters the state of the art?
Well, yes, sir, but I mean, state of the art, I mean, these are basically just they're similar to the filters you have in your air conditioner. I mean,
The
they're
reason
just,
I'm asking is because the Lee County approval was based upon there being state-of-the-art
correct,
equipment.
yes, sir.
And you're raising some questions as to whether it is state-of-the-art or not.
No, what I'm saying is, when you say state of the art, I'm not sure what your preconceived notion is on this.
I don't have a preconceived notion.
Okay. The state of the art,
That was in the law that was
right.
passed by
And
Lee
it's-
County.
It's basically a filter system that catches these fugitive particulates.
But there are all kinds of ways to catch that.
Correct.
Some are effective and some are not effective.
Well, these are pretty effective. I mean, these are generally what are perceived to be the proper and most cost-effective way to collect
Well-
fugitive particulates.
So then on August 27th in 2002, when the mine entered into an agreement with Citrus Park, if these were so effective, why was it necessary in the agreement, it's recognized that one of the adverse impacts, not my words, of the mining operation was dust. And also that dust created by the mining operation, and then dust created what they call the manufacturing operation in those agreements. Why was it necessary to have an agreement if these were so effective?
Well, I'm not going to speculate.
Are they any more effective today than they were in 2002?
Oh, yes, sir. The answer to that is yes.
Why is it important? Maybe you're not the right witness, but why is it important in a mining operation to require that water trucks, and in this case, you're required to do that at least twice a day?
Correct.
Why is that important?
Because when you transport from the mine face, the working face of the mine, over to the processing area, and then from the processing area out, the fines, which are almost as fine as talcum powder. I mean, they're called fines for a reason. They're very fine material. There's a certain amount of that comes off of the excavated material. And since you're transporting them in trucks from one spot to another, they're going to get out onto the road system. Now, additionally, the interior road system is also, it's not paved. It's just basically a rock road that they move around on. And so typically in these excavations, you have water trucks that go around and water everything down. And that's one of the reasons we work with the rock wet like that, so that the fines are kept down and we don't get a dust problem. But yes, I mean, dust is always a concern, and that's one of the reasons why.
Why is it a concern? Why is
Because out here in the heat, the dust itself, because it's so fine, will get picked up, and the truck traffic will make that dust move around.
Right. And why is that a problem? Is it because that dust contains nasty stuff?
Well, it's just, I don't know what the chemical composition of the stuff is. You'll have to ask a chemist for that, but I can tell you
Crystalline
it's
silica?
a problem.
Is crystalline silica limestone?
Typically, as I understand it, and this is secondhand from geologists, that silicate is not a significant component of lime rock.
If I could, I'd like to follow up. The LEED plan indicates that you have to have a plan to deal with fugitive dust. Is that correct?
Yes, ma'am.
And dust is damaging to the very expensive huge trucks and equipment on the site.
That is correct.
And so, condition 14, I think which the chairman's referring to of Resolution Z02-047, provides that the internal roads must be watered by the applicant not less than 2 times per day during the dry season. And that's obviously for dust control, correct?
Yes, ma'am.
And then there's also a condition that the wheel wash must be installed within 6 months following the approval of the plan development. You've dealt with several mines. Can you explain for the benefit of the board what the wheel wash is and how that works?
The wheel wash is a facility that the trucks go through on their way out of the mine. It's basically a high-pressure spray that is directed at the undercarriage and the wheel mounts of the trucks. And the idea is that anything they picked up on the site should be washed off. It gets caught in basically a containment system and ultimately goes back into the mine lake itself before they get out onto the roadway. And the idea here is to keep these fugitive particulates from exiting the mine site and getting out onto the roadway.
And so conditions like that condition are standard conditions in almost every zoning resolution that Lee County has issued on mines.
In the last 2 decades, I have not seen an approval that did not include a wheel wash.
So it's a normal request to
Yes,
address
ma'am.
the operation.
That's correct.
Thank you.
Mr.
I want to
DePuy.
go, back to, I know you hit on it, I think it's slide 15. I mean, some of the questions I think that the chairman asked suggest that there's a concern about noise, and you kind of glossed over this, but many of the conditions you highlighted there were included to address noise so there wouldn't be an off-site noise impact. Is that correct?
Yes, ma'am.
Okay, thank you.
Mr. Inserpi?
Mr. DePuy, back in 2002, when the agreement was reached with Citrus Park and Bell Villa, a couple of things that were brought up were the noise, the hours of operation, and the damage caused to the homes, whether it was in Bell Villa or whether it was in Citrus Park itself. And that was supposed to be addressed. To date, it hasn't been. There are a lot of people out there that are still waiting for somebody to come out there and fix the damages to their homes.
Well, I will personally apologize to you. I thought that it had been taken care of. So if you tell me it hasn't been, we will address that. Now, the only thing I can tell you is that that mine and the ownership of that mine has been through a lot of changes since 2002. The Hubsmans are gone, and then the next set of management came and went, and then the bank came in, and then the next bank came in and took that bank over, and then the bank sold it off. So, I mean, it's been through a lot of management. I was under the impression that that procedure had been adopted and was in place. If it's
I'm saying
not,
that
we will,
mine hasn't reciprocated and taken care of. They have, some of it, not all of it. Biggest problem was the hours of operation when they were mining. Every time they dug, that explosion, it rocked everything. And apparently it still does, because it's still digging. So now we're talking about digging until 2041. That's,
So, let me follow up on that. That's
go ahead.
the question comes out of this, this agreement was not only about the dust, but about the noise. And with regard to noise, as of October 31st, 2019, if my recollection is correct, the mine conducted 7 blasts on the property. If we agreed to this, then it will go to 50 blasts per year on the property. Am I correct on both those?
I'm going to express a concern at this point in time and ask for input from Derek and David. With construction materials aggregate, blasting is not regulated by the local government, then preempted to the state. Blasting and compliance with blasting requirements is regulated by the state fire marshal. And if there's any concerns regarding damage, that is handled through a process established by the state fire marshal. So that's not something, in my opinion, and I'll defer to these folks, that the local government has control over.
Do we have authority, Counselor, in your opinion, to look out for the interests of the people in Citrus Park and so on? Or are we barred from taking into account the human costs associated with this?
Blasting is highly regulated by the state. And there are, by the way, there are hours of operation in the current 2002 resolution. But blasting and how it's conducted, I mean, it is regulated, but it's not regulated by local government.
That doesn't answer my question. Can we take into account the people in Citrus Park and the impacts of this operation upon them, or we're not allowed to look out for their interests?
You are definitely allowed to look at the impacts on people, but you're not allowed to regulate blasting.
I don't think anybody here was suggesting we were going to regulate blasting, but I'm just pointing out 7 blasts. If we approve it, it goes to 50 blasts. I'm not saying we should limit that or not. That's the facts that are presented to us
Well, and I would say.
in the materials that you presented.
Typically, they're.
The engineers presented that as, that's not me.
Typically, the maximum you would have would be 3 blasts in a week. You wouldn't have, 5 blasts in a day or anything like that. But Dave and Mr. Straw are the experts.
What would be the minimum, how many blasts are you talking about?
3 blasts a week.
3 blasts a week. Have you ever been out there? Just let me ask you a question. Have you ever been out to Citrus Park when they blasted out there?
I've been.
Or have you been anywhere on Bonita Graham when they blasted?
Yeah.
No.
What I would tell you is that, yes, I mean, there is no question that you will detect the blast. But that's not the standard. The standard is not that it's undetectable. The standard is measured as a peak particle velocity, and it's a question of whether it does damage to structures. And that's how the state measures it. That's how the seismologists all report the data. The blasts themselves last on an order of 3 or 4 seconds. So over the course of a year, if there's 50 blasts, you're looking at maybe 3 or 4 total minutes out of an entire year in terms of the actual time that is blasting. Now, I'm not saying that you're not going to detect it. You detect these things.
Absolutely.
But what I'm saying is the measurement that the state statutes reflect are actually empirically based, and they're related to, as I said, peak particle velocity. I'll get Jeff Straw up here to talk about it if you want. I can tell you your ears will start to bleed even worse than a planning presentation, but if you want to, he is the encyclopedia about virtually everything that's blast related. He'll be able to answer any questions you want. But
Yeah, and I would say this, I mean, lots of folks raised concerns, and so the state undertook a study last year, I think it was, and one of the mines they studied was here in Lee County. I think it was the Youngquist mine, to determine whether or not the state should change their standards because of concerns raised by folks. And it's my understanding, based on that study, and Jeff can confirm this, they did not make any changes. Is that correct?
I would, to your question about compatibility issues like that. So you are reviewing this application under the Lee County Code as if you were sitting in the place of the Lee County hearing examiner.
Correct.
And specifically for mining PD amendments, the criteria would be compatibility, noise, dust, odor. These are the things that you can take into consideration. I'm getting a little concerned about is we've talked a lot about complaints and issues back from 2002, and I've been asking staff, we have no records of any complaints or any issues existing presently. And the city does get, I see that reports come in, the seismologist reports on the blasting and all that come in, but I'm unaware of any complaints on the record about continuing issues.
Has the city gone out and asked the people if they have any complaints? Oftentimes, people give up because the government is non-responsive. But if you go and talk to them, you'll elicit a very different response, Mr. Rooney.
I believe that some notice was provided to Citrus Park about these hearings.
I understand that, but that doesn't answer my question. Have people gone out and talked to them from our government and say, do you have any concerns here that we could bring to the attention of the zoning board?
There's been 2 neighborhood, or at least 2 neighborhood informational meetings. The records of those are available.
Right.
And it's my understanding from the last one we had, and that there was in fact a meeting at Citrus Park regarding this application and the next application. And actually what the gentleman said is, he thinks this, essentially the city made a good deal in the settlement agreement, and, you know, he didn't have a problem with it, and the community apparently didn't have a problem with it. So that was the feedback we got.
Okay.
First of all, Mr. Shant was not from the area out there, okay, that's number one. Number two, nobody, and I lived out there till 2011, okay? I was very active with it, very instrumental in it. Nobody, but nobody has ever gone out there and held a general meeting with the populace about the mine corporation, the noise, the damage that was being caused. Never.
It's my understanding that a council person went out there and spoke with them.
That's the person who should go.
That was a councilman. A councilman did come out in 2009 or 8. That was that. But since then, nobody's gone out there. I mean, when was a councilman, you know, somebody should be that's involved with everyday activities should be out there. Simple. I mean, you know, the constituents are the ones that put these people in office. And the constituents are the ones that are paying for everything. So they've got a right to live harmoniously and don't worry about damages all the time. And as far as I'm concerned, I don't think the mine corporation has been a good neighbor. I don't think so. You know, go look at the truck traffic. Look at the truck traffic on Terry Street. Look at the truck traffic on Bonita Beach Road. You know, nobody's monitoring that. There's nobody out there monitoring it, sitting there with a gauge telling how many trucks go by. Nobody's doing that. So as far as I'm concerned, I don't think the mine corporation is doing what they're supposed to do.
Let me just respond just briefly, because Mr. Inserpi and I have, at least unfortunately, 20 years of history, as I can recall. And we have known each other for that period of time, and I have great respect for Mr. Inserpi. And I would tell you a couple of things. Again, I would say, remember, the recession and the change in ownership and the foreclosure and everything on this property really put management in a difficult situation. But I'd also point out that this could have disappeared in 2005. I mean, that's when the annexation took place in 2003. The expectation was that in just a couple of years, there wasn't going to be a mine out there anymore. So I'm not trying to hand out blame to anybody. All I'm saying is we're now in 2019, and we can sit here and kick around what happened in the past, but I ain't going to get anybody anywhere. What we've got to do, I think, is look forward to how can we make the mine and the property on which the mine is located a good neighbor going forward. And unfortunately, we're wrapped up in a tussle with the city over the litigation, and this is the settlement that everybody agreed to. So what we're going to try and do is make the best of this, go forward, and ultimately, I'm hoping that I'm back in front of you guys in a fairly short order, showing you what the residential community out there is going to look like and telling you when the mine's going to shut down, so that we can become a good neighbor to Citrus Park and Bellevilla and some of these issues that Mr.
Show us on the property map that you have in front of you where the residential property would be.
Basically, in this area here, this area would go to the city.
Are we facing north?
North is this way.
North is that way. So west is
West is
that way.
down.
Right.
East is up. South is to the right. North is to the left. So this area, which is adjacent, I should go back into the microphone. This area over here, which is adjacent to the Edison Farms property, would end up in going to the city as part of the conservation and park area, and then the area to the south. And the area along the east side is already in conservation, so the area kind of to the south and southwest would be the area that would have residences wrapped around the lakes.
And this residential development will begin after 1941 or 2041?
I'm hoping it's going to begin much sooner than that. But Again, I can't commit that to you because we've got to get the rest of the settlement in place.
Oh, it would start
We have
right
to
away.
make the other
Mr.
hand.
Depew, I just brought those concerns up, because maybe perhaps while you're sitting here negotiating a new contract, whatever, that this is, the mining corporation should be cognizant of the fact that these concerns are still going on, that's all. You know,
And I appreciate it. I
Most of
do.
you could probably rectify.
And initially, you're looking at putting together 700 homes?
About
initially?
700, yes, sir.
Can we take a break now, just for 5 minutes?
Yes, sir. Thank you.
Let's make it a 10-minute break. We'll reconvene at 10:45.
And I'll
11-minute.
take
count on a council person
Well,
to
if you
go
can't, then
forward.
you don't have
I'm not
representatives.
saying it. What I'm saying is, cities
The Lee County Commission passed Z-02-047, using the same regulations under which you all are reviewing this request.
In the back of the room,
Hey,
guys,
come on.
go outside. Thank you.
Using the same regulations under which you all are reviewing the request, they found that the rezoning met or exceeded all of the performance and location standards, was consistent with the Lee Plan, was compatible with surrounding land uses, did not place an undue burden upon infrastructure, and would not adversely impact environmental or natural resources. They further made a finding that the protected uses, or the proposed uses, were appropriate for the location. The conditions provided were adequate to safeguard the public, and the conditions were reasonably related to the impacts that were anticipated by the development. The necessary urban services were available. The deviations that were proposed, none of which have changed in the current request, were conditioned sufficiently to protect the public health, safety, and welfare. This is the master concept plan that was approved under Z-02-47. Again, north is to the left on this slide, south is to the right, west is to the bottom, and east is to the top. The operations area are in the same location as in the proposed amendment, and the preserve areas have not changed. The preserve areas are those hatched areas that you see on that slide. This is the most current site plan that was approved under ADD 13-05138-BOS that was approved by the city as part of an amendment that regularized the current excavation activities. The lake areas are a little bit different from that which was approved under Z-02-47, but they are substantially the same. And the location of the various uses are the same, including the preservation areas, which have not changed. It's a little hard to see, I know, because it's over the top of an aerial photograph. This is the proposed master concept plan that's being sought by the amendment and the settlement agreement. The lake area has been expanded by, as I said, approximately 299 acres, but again, the preservation areas and the operation areas are the same areas that have already been approved. Let me give you something that's a little bit better in terms of showing you what the expansion is.
So how big, how much of an expansion, is it 299 acres?
299.
Additional that you're asking to be mined?
Correct, yes, sir.
Thank you.
An additional, roughly 300 acres.
300 acres.
And the areas in blue here are the expanded mining areas. The areas in gray are the areas that are the existing lakes. And the areas in green are the preservation areas. So that's the expansion on the property. And I know it looks like there's not much land area left, but that's because you've got 2 square miles there. It's a big piece of property. So even small little areas are pretty wide. So there's wide enough areas around the lakes to ultimately establish the residential uses that are proposed as part of the settlement agreement. We've looked at the surrounding land uses in the area, specifically the distances to the nearest residences. You can see there's over a quarter mile to any of the residences from the property boundary of the subject property. The yellow arrow shows the closest residence to the south. That's approximately 1,425 feet. The blue arrow shows the western property boundary at the southwest corner, approximately 1,882 feet to the western property boundary. And the red arrow, or fuchsia, or whatever you want to call it, pink, shows approximately 1,676 feet to the closest residence on the western property boundary.
Are there currently dewatering operations?
There are not dewatering operations in there right now, no, sir.
What does
Are there
dewatering mean?
plans to have dewatering in the future?
Not for any of this mine anymore. Typically, when you mine, the overburden is extracted in small areas through dewatering, but this mine's been through all that, so no, sir, there's not really any intention on doing that. Although the dewatering, there is a dewatering permit that is in existence from FDEP.
Right.
Would you just tell me what dewatering is? That was word.
Yes, ma'am. What happens is on the overburden, because the water table is so close to the surface, And you want to be able to what they call pan, in other words, use a grader to pull the overburden out rather than bring the dredge in or the bucket, the drag line in for that. They will typically, they'll have what's called a recharge trench, and they'll pump water out of the excavation area into the recharge trench. And the recharge trench is typically located between any water-sensitive activity or water-sensitive use, for example, wetlands. And they'll fill the recharge trench with the water from the excavation area, so the excavation area is dry, and you can get a dozer in there to pan that out or scrape it out till you get to the actual rock. And the pumps will pump that water out and put it in the recharge trench so that the hydraulic gradient between the wetlands and where the water had been doesn't change, so that the wetlands don't dry out. And so that's simply what dewatering
It
is.
was a phrase.
That's a planning explanation, and I'll go back to Chairman Kurlander's comment before too about silicate in the lime rock. I'm not a geologist. I can't give you an answer other than my imperfect memory of discussions of geology with geologists.
Oh, wow.
And I don't have a geologist here today. As I said, my recollection for the type of silicate that is involved in hazardous breathing and respiratory problems comes from my discussion with Tom Mismer, a geologist locally. He said that it's less than 5% of that material. Now, that's not saying that there's not more silicate in there, but he's just saying that that's the type of silicate that becomes associated with respiratory problems.
So,
But again, I'm not a geologist, and I'm not trying to give you geology
1%
testimony.
is a good number. I come out of the mining business. I should disclose to you. I was the chief administrative officer of Newmont Mining, the largest gold mining company in the world. As part of my duties, I conducted environmental audits all over the world, including the United States, and I'm familiar with these issues. And I'm familiar with, but I'm not here as an expert. But I want to tell you that it is my understanding that the reason that you're watering at least twice a day is because any dust particle that has less than 10 micrometers of aerodynamic diameter, is carcinogenic.
I wouldn't dispute it.
And that's why that regulation and why it's important that that area be. Now, I don't want to be an alarmist here. But the reason that that's in place, in part, is to protect people in the area, and it becomes relevant when you want to put residences in the area, because by itself, the dust is not harmful.
I'm going to express a concern about that because I know that there's been folks from Pennsylvania and Northeast who dealt with coal mining. Limestone is not the same chemical compound nor the same, doesn't have the same, as I understand, carcinogenic element that coal does.
I don't know anything about coal. I was in the gold business, not the coal business.
Okay.
So, and the chemical composition of a rock is the chemical, it doesn't matter what you're mining. And think of it as quartz. So the rock that limestone is contained in has two major ingredients. Limestone, roughly 99%, and silica, or quartz, but in particular crystalline silica is the most common, 1%, or somewhat greater, but in that area. And I think that we know what the issues are with regard to that. And the question is whether or not, if you put 700 houses there, over time, it's only if there's repeated exposure to the dust. By itself, it's not a problem. But if you sit there, if you're, let's say you're operating a truck and you're there every day, all day long, and there's been no watering of those roadways, you're inhaling a lot of dust.
Have a health issue.
You're inhaling, and those don't appear for 25, 30 years down the road.
And there are typically a variety of MSHA requirements for, particulate control. MSHA is the
Right, the mining.
mining.
OSHA of
It's
mining.
the OSHA of mining, basically. And there are those regulations that are in place, and the operators out there are intended, the intention is that they follow those requirements. And the other thing I'd add to you is, we're well aware that once this gets finished, we're going to have to bring in topsoil. This is not going to look like this when it gets developed as residences. There's going to have to be topsoil brought in, because right now, this is
So I
pretty
want
much.
to address that question to the council, to all three council here. As I understand what's in place, emergency orders aside, that there's somewhat of simultaneous reclamation that's required on this project. When you finish mining an area, a particular area, you've got to reclaim it. Am I correct that that's what these agreements call for?
I believe you are correct, and I believe Dr. Depew will testify that they have not finished mining in any area at this juncture.
So that's my point. So what they do is they create an area that's 100 miles long, and therefore they don't have to reclaim it. So we have experience here. We know that someone in the past has defaulted, went bankrupt. Who gets stuck with the bill to reclaim the property? Because it has to be reclaimed. Under federal law, it must be reclaimed at
There are
some point.
bonds in place.
That's it, there's
It's
performance
bonded.
bonds.
There
here
are
that say
performance
that-
bonds in place now.
You now have a performance bond, right? And is that performance bond in perpetuity?
It's in-
Or if the premium is not paid next year,
I would have a question about that, because it specifically says in here that the performance bond has a 10% increase on its face value every year. And my question was, is the performance bond up to date? Has it been
It is up
provided
to
to the
date,
city? And has it had the increases that were supposed to have been happening over time?
My understanding is it is up to date. The necessary increases have been put in place.
Is that the understanding of the city?
The bond is tied to the DEP permit.
Pardon?
The bond is tied to the
Correct.
DEP permit. The city is not the beneficiary of that permit.
Okay, so that
We're not-
performance
we're not
bond would
involved.
go toward the reclamation if they defaulted or something?
Correct.
And that is, because if we are going to go forward and approve expansion of this mining, and they don't go to residential, which, obviously that's not what's before us at the moment. The question before us is, should we expand the area that you can mine? I think the expanding it to 2041, based on some of the things you've said, is pretty sort of remote possibility that you'll run out of things to mine long before then. But assuming we do the 2041, the big change here is the area over which you can mine. And if you don't go to residential, and we don't know that that's even an issue, it's not before us, we would want to know that there was a way to assure that that reclamation would happen. And what it says in here, at least, is that there are performance bonds that are supposed to be provided, and so I just want to make sure they are provided, and that they would continue to be provided if we were to increase the area, which would mean more to reclaim.
My understanding of the performance bond is up to date, and the performance bond is based on the DEP mining plan, which is the expanded mining plan.
Okay, that was a question I had. Answered.
Am I wrong, Ned? I think that's correct, isn't it?
Well, and to the question of whether or not residential can be accommodated around a mining lake, I believe that there are several examples in both Collier and Lee County, Miramar Lakes, or Harborage, West, or Wild Blue,
Wild Blue, Corkscrew
Lake
Shores.
Park.
Yeah, Lake Park.
and in all
But-
of those places, there's simultaneously mining going on?
No, they
And
finished, they
it's
finished.
finished.
Wild Blue there is.
No, there's no mining left on Wild Blue.
Signs posted. No, that's adjacent.
That may be at the Youngquist, just to the east. But the reclamation and the residential use is simultaneous. That is ongoing on Wild Blue. And the Corkscrew Shores, I believe they're done with reclamation on that one. Miramar Lakes, they're done.
Place on Corkscrew.
Yeah, that's Corkscrew. I don't know exactly the name of the development now. I always knew it as Corkscrew Shores.
Corkscrew Shores is on the south side. The
Yeah.
place is further out.
Okay, yes, that one.
Yeah, the
Across
place wasn't
from
defined
Old
anyway,
Corkscrew.
Okay, but that wasn't a mine.
Wasn't?
No. It was requested for a mine excavation permit and it was denied and ended up in litigation and the county won that. So, anyway, this is a depiction of the lake cross-section. It shows the separation between the lake areas, the easterly preserve on the left. Middle drawing shows the internal location of the lake versus the internal preservation. And the drawing on the right shows the separation between the lake and the Hall Road. And just of interest to this is simply you see what happens. The slopes drop off after a fair amount of going out well into the lake, but the side slopes right along the edge are fairly shallow for lake operations. This is the proposed reclamation plan. It creates 3 lakes, provides for side slopes along the lake banks with stabilization. It maintains the preservation areas. So the 3 lakes, again, are located in the north area, located in the central, and then located to the south. Lee Plan consistency, the future land use policy for Lee County's plan designation on the subject property is 1.4.5. As noted there in the highlighted language, natural resource extraction and related facilities are recognized as permitted land uses. The original request was found to be consistent with a number of other policies in the Lee Plan, both by the staff, by the Lee County Hearing Examiner, and by the Board of County Commissioners. So all 3 agencies of the county in 2002 found this particular request in 2002 consistent with the plan that was in effect at the time. Additionally, the request was found to meet all the applicable requirements of the county's land development code. The conditions were deemed sufficient to minimize any negative impacts that the operations might create. The approval granted by Z-02-47 included specific findings that the request met the Lee Plan goals, objectives, and policies, along with all of the Land Development Code performance standards. Further, the request was deemed to be compatible, and I would note the conditions in the surrounding areas proximate to the mine have not changed to any great extent from that time. There was a determination that no increase in anticipated traffic would result from the prior approvals, and that all the preservation areas were identified and set aside in conservation easements. The conditions were deemed sufficient to protect the public interest. Thank you for your attention. I am available for any questions. That concludes the applicant's presentation. Unless you have specific questions, we have some of the consultants here that might be able to address them. But as I said, that is the end of our formal presentation. Thank you very much.
One thing that in the paperwork that came up was that as a result of this truck traffic that's generated by the mine, there's been illegal dumping on Bonita Beach Road. That shows up in the in the materials. I think it was in the project request narrative where they talked about the illegal dumping on, is that in any way, was that taken up by any of you in your settlement agreement? So the truck drivers, it's not the mine, it's not mining materials that are being illegally dumped, let's be clear. It's other things that have been illegally dumped. But it comes from the truckers. And there was a question as to whether you can control the truckers, or how do you deal with that?
Like what was dumped? What materials?
Coffee. It doesn't say, it doesn't specify, but that was my understanding.
You mean out of the window?
Out the window, kind of dumping.
Oh, okay.
And that it's,
Pollution, paper.
I mean, that's littering. I mean, that's,
That isn't how I read it. I thought to prevent illegal dumping, the mining company agreed to monitor for that and try to make
Right.
sure to stop it and to educate not to.
Right.
But I didn't get any notion as to what was being dumped or whether it had happened. So the question I guess I would ask is, has there been any evidence of illegal dumping that the city has had brought to their attention?
I'm unaware of some. So it was not raised in anything in the settlement agreement because I'm unaware of any dumping.
As part of the compliance agreement, the mine was requested to provide its best efforts to
Yes.
attempt to help control that, and we agreed to do it. But right now, I'm unaware of any, and you haven't heard.
Okay.
None of the operators know anything about this, so, we're happy to control it as best we can, but if, and we advise our drivers not to.
Sir, is the owner of the mine the operator of the mine, or
At this
does that
point, yes, sir.
does that get subcontracted out?
Operators are employees of the owners.
They're employees. Okay. So you're done with your presentation
I am.
for now?
Unless you've got more
Right.
questions.
More questions?
I think you've heard enough of me.
Thank you very much. It was very helpful. We'll now hear from the city.
Good morning, Chairman, Zoning Board. For the record, Jacqueline Ginson with Community Development. Our presentation is rather brief. I apologize. Our presentation is rather brief. However, please feel free to go ahead and stop us to ask for any questions you might have. But generally, we are in agreement with the applicant's information that was submitted to us. There was one area that we went ahead and added a condition relative to buffering. I don't know if the applicant is objecting to that item. I haven't heard as such, but other than that, staff was in agreement with their analysis as submitted. This is the staff review team that assisted in the review of this application. Who I have here today, though, is John Dolmer with Community Development, our director, Mike Kirby, who has extensive knowledge of the mine since our department was formed in 2008. So he has a lot of knowledge on the compliance agreement, has an extensive biological background. So he's here in that capacity. And then we also have Ms. McCarrack here as staff's attorney for the case. We already went over the request. Staff is recommending approval with conditions on this amendment request. Again, with the overview, a lot of this is redundant, so if you would like me to go over it, I may. But essentially, this request is continued from your last month meeting, so the board could be afforded more time for analysis because of the intricacies of this case. We are attaching a lot of the previous zoning entitlements to this existing amendment, which will result in a zoning ordinance. And again, this has an extensive history based on the annexation agreements and other agreements going back to 2003. And we're here today reviewing this under the Lee plan and Lee County LDC because we don't have a city designation. And again, because of the settlement agreement, and also there's a provision in Florida statutes that allows the applicant to request to be heard before you today on this request. We already went over the citywide location map, so you're pretty familiar where the location is. The applicant also provided you the same aerial that we have, which is an exhibit from their analysis. These are just excerpts from the staff report that go over the existing land uses of the property in itself, the surrounding areas as well. Very, very slight changes have occurred since 2002. As the applicant testified, the county did purchase the property to the north. Lee County Conservation 2020 staff is currently working on implementing park programming and funding for that recreation area. That is why staff is requesting a condition regarding the northern buffer because the mine would operate adjacent to a future county preserve that will be programmed with passive park activities. So those are some of the changes since that time that this was heard in 2002. Regarding the master concept plan, Mr. Depew went over the various sheets in detail, so we won't go over that unless you have specific questions. But it is a 6-page master concept plan, and underneath the bullet, I have identified what those 6 sheets are. That is included as your Exhibit B in your staff report, which is a better resolution than what I could go ahead and put on the slide. But again, Mr. Depew already went over that in his testimony. So again, if there's any questions, I can answer them, or Mr. Kirby can. Regarding the schedule uses, development regulations, and deviations, they're not asking for any new uses. They're not asking to change any of the development regulations in terms of setbacks and the location of certain uses. They will all maintain consistency with the prior zoning approvals. And then there's no additional deviations. So in that regard, there are no changes to those sections of the entitlements. With the Lee Plan and Land Development Code consistency, again, staff is relying heavily on the 2002 analysis because not much has changed since the amendment was approved in 2002 and when the city annexed this property. As you know, several of you had the opportunity to review the codified sections of the Lee Plan, the county's land development code that was in effect in 2003, and very little has changed. So we relied a lot on that analysis and the applicant's analysis, and found the request consistent with those documents. In terms of neighborhood compatibility, the applicant did hold 2 neighborhood meetings. Those notification requirements do require an ad in the newspaper. They also require mailed notification to all property owners within 1,000 feet. So at the first hearing, I don't believe anyone attended the meeting. And then at last week's meeting, there was 1 member of the public that attended. With mailed notices, I did get a response back from 1 property owner that had multiple strap numbers or parcels, where they just checked that they were opposed. They didn't necessarily tell me why. Another participant had contacted me via email. She was concerned, but once she read what the request was, she didn't think it would impact her property. She just asked to be kept apprised as the mine applications move forward. So other than that, again, I believe we can learn more tomorrow. I know Councilmember Caramba is the representative for the Citrus Park District, and she generally is very active with her her constituents in the area. So I know she has had recent communications with Citrus Park, and I believe the mine was a topic of discussion, and she can probably fill in the public tomorrow on those discussions. But the gentleman that did attend the meeting last week was from Citrus Park, from what I understand. So with that, with the neighborhood compatibility, a lot of the concerns that were in that Citrus Park agreement, and it is referenced in an exhibit in your staff report, or I'm sorry, as an attachment. What the staff had done in 2002 was look at that agreement and go ahead and prepare conditions and added them to the 2002 zoning resolution that addressed those concerns that they thought they could go ahead and enforce. So those conditions were incorporated into the 2002 conditions, and those conditions are not changing. The private agreement has expired, but we as a city have not gone ahead and required them to. We can't enforce, we're not party to that agreement, and you'll see that also in the hearing examiner's report, her position on the agreement as well.
Could I ask a question? Has there been any effort, I guess this is for you, from Citrus Park to ask to extend that agreement that expired in 2018?
Not that I'm aware of, ma'am.
Not you were.
And Citrus Park was just acquired by another entity as recent as this year. And I believe even that new management company is still trying to work with Citrus Park as a whole on a variety of items.
Falls between the cracks.
So new environmental considerations, I already touched on the northern perimeter berm and buffer as a result of the county's property now to the north being activated as a passive recreational use and a preserve. So that is a new consideration. Existing environmental, stormwater, and traffic considerations, just went ahead and identified those by topic. These are all items that were addressed in your staff report. And again, Mr. Kirby's here to talk on anything that you might have questions about in the environmental realm. For stormwater management, the system is designed for the 25-year, 3-day storm event. And then there's certain items in here about the discharge at certain peak events. Our engineering team did review the stormwater narrative, and they had no objections to the narrative as written. In terms of transportation, Lee County DOT, Public Works, and our city traffic analyst did review this request, and they agreed that there were no adverse impacts to the network. And this is attachment A in your staff report, because I know there's a lot of text on the screen, but this is just an excerpt from the Lee County Land Development Code outlining the criteria for review for how you evaluate this request and provide your recommendation to the City Council for final agency action. So again, this is the last 2 pages of attachment A in your staff report. And based on those criteria, we have provided our findings in the second column. And with that, I'll go into the conditions. So the conditions of approval are outlined on pages 4 and 5 of the staff report. So condition 1 is the timing and the effect of the zoning entitlements. It also ties it to the 6-page master concept plan, which is referenced specifically in condition 2. Condition 3 is our environmental conditions, where we address consistency with the reclamation plan. We have a prohibition of open burning. As part of the compliance agreement, there were open space areas that the applicant had to complete. They are still working on the northern open space area. There's been some natural conditions that have prevented them to complete those. So those are still in progress, and again, Mr. Kirby can testify to those. And then in condition 3, we also have the northern buffer.
I have a question for you. Would these conditions supersede the conditions that were laid out in the consent agreement in 2009?
The compliance agreement?
Or would those be still in effect?
So what we did with the compliance agreement was attached in the 2009 zoning amendment. And I'm probably going to defer to Mr. Kirby a little bit. The compliance agreement, for the most part, is almost complete, except for that northern open space area.
Well, it requires that the trucks be on the road at least twice a day, internal to the property, watering the property twice a day, at a minimum. It requires that there be a wheel wash. It requires noise mitigation. It requires dust mitigation. It requires a ton of stuff, none of which is addressed in your conditions.
Actually, condition 1 ties, it says all conditions of the Lee County Resolution Z98071, Z0247,
Right.
City of Bonita Springs administrative actions, 0980.
So both,
So yes, we do have the
County
compliance agreement in that
carries
condition.
over. Do you agree with that, Council?
Yes, I do.
Okay. Thank you.
You're welcome. Condition 4 kind of supplements the truck use condition that was in the 2002. We went ahead and just kind of tightened that up, if you will, based on some feedback we had in the
Can I ask
community.
a question about that too, though? Didn't we just hear that there wasn't any way to enforce that? Wouldn't we need to have the city of Bonita Springs put a no truck traffic on this? At least as I heard the applicant discuss it, there wasn't any way you could tell a truck that they couldn't use Terry Street. So I don't know what the meaning of putting it in there would be.
The mine operator, as they testified, they do educate their individual contractors that haul the material out. They do have signage. So to that extent that they can control it, they have made those efforts. And then I guess for us, from a local ordinance with the county.
Basically, you're saying this is a
Sure.
requirement without any teeth. It doesn't have any enforcement provision at all.
So those people are not employees, is that what you're saying? Those are subcontractors?
Truck drivers?
Yeah,
They're independent contractors.
they're independent contractors.
But you have no control over them.
It just seems to me this is a kind of a provision that you put something in the law that has no way to enforce it, that encourages people to have a disregard for the law. It would be better not to have it there than to have something that you're never going to enforce there.
To your point, could you bar them from moving materials out of the mine if they were not
The answer is,
respecting the roadways?
the answer is yes. They would be, if, I'll call it agents of the mine are operating on Terrace Street in violation, then they would be in violation, and the city could use its code enforcement processes against them. Alternatively, the city could close Terry Street to truck traffic. All these things could still have people violate them, and we'd have to enforce them through the sheriff or their. Again, I'm not aware of any evidence that that Terry is being currently used.
But could,
It's not that it's not enforceable. The question I'm trying to, is there an issue?
So you haven't had any complaints from residents on Terry?
We have no evidence of any
there
issues.
were some,
Material.
some years ago. But my question was more, could the mine bar a particular driver, trucker, from entering the mine if he was
And that,
dumping or
that would
not
pro-
complying with local ordinances?
that would probably be the ultimate practical result. If they're in violation and the city uses its efforts against the mine will use efforts to bring in its drivers into compliance. We're not trying to get into that level of, we're not drilling down into that level of detail with our conditions.
Yeah, and one of the things I can tell you is like the Alba Bridge, and it used to be 31. Some of those bridges had limits for trucks above a certain weight.
Wait, yeah.
And I actually just last week saw the sheriff department had a truck stop at the Alba Bridge. So that's an alternative the city could pursue.
And I do believe, I just have Mr. Dolmer come into my ear, that when there were issues on Terry Street, we did coordinate with the sheriff's office for their assistance. So, but again, it's been quite some time. The last time I recall there being a concern, it was when Councilmember Janet Martin was on the board. So it's been quite some time.
So the applicant, I think, here, the bottom line for, the applicant has raised a fair point here, that, you know, a lot of this stuff that went on was prior owners. Under the agreement, you're required to monitor portions of that agreement. You're required to see that they are watering. You're required to see that the noise is within acceptable levels, that the vibrations are so on. There's regulation or things that deal with that. And their point is, you know, you can't go by history, there's a new owner, and that they're more responsible. Is that so? Is that right? Are they more responsible? Are they complying with the rules?
This owner is
Yeah, this owner. I'm asking a question.
So we have not received at our office concerns ever since, and depending on the issue, but.
That wasn't my question. My question is, are they complying with the agreement?
Are there any code violations?
From my understanding, the city is unaware of any violations on the property.
Thank you. Continue.
The next item is number 5. So this is based on direction that City Council had previously provided a statement that there was no intent, but they did not want the alignment of 951 to go north through the city of Bonita Springs. So in the 2002 zoning, there's a condition that they show the alignment of the future County Road 951. So based on the prior council direction, we have a condition in here that repeals that condition for council's consideration. Condition 6 deals with engineering and the requirement of them obtaining their ERP modification and a maintenance entity for the stormwater management system. And condition 7 is really a boilerplate, what I call condition of approval, that essentially says that they have to prove that they have addressed any pedestrian or vehicular impacts at the time of local development order. So essentially, this zoning does not guarantee them their local development order approval. So that's a boilerplate condition. And that,
As it stands now, would the applicant be required to do any reclamation prior to 2041? Under the current setup.
I would defer to the applicant on the reclamation plan, because it, from what I understand, it is a complex timeline depending on what they're digging and the materials out of each lake.
I didn't think my question was complex.
It's like everything in life, it's more complicated than you might expect. The
So maybe
answer
you
is
can help
that,
me
yes, they
understand.
could be required to do reclamation prior to 2041 if we're finished excavating in one of the three lakes. It's when we get finished excavating in any one of the lakes, then we start.
But you could say,
Within
"Oh,
6
I'm
months.
still excavating."
Yes,
That-
and if
that
they're still
extends.
excavating, then they're not required to do reclamation. That is correct, sir.
Did I
So-
misunderstand, excuse me,
Go ahead.
did I misunderstand that? I thought it was the state's responsibility
It
to
is, yes,
oversee
ma'am.
reclamation, and so it
And-
isn't a city
And that
responsibility.
brings up one of the staff conditions, 6A. Ms. Jensen, you've got documentation of the South Florida Water Management District ERP modification.
It is
It's actually FDEP, it's not the district.
And I've changed it in the ordinance.
Okay,
Thank you.
just a minor little thing, but
Yeah,
I know.
That's
It's
okay.
one of those things that you need to kind of keep track of, so.
Thank you.
Do you have any questions for myself or Mr. Kirby?
I don't have any questions. I just want to point out, since we sort of jumped into all the procedural history, we didn't go through and ex parte disclosures, if there had been any, on this matter, or site visits for anyone, just for the record.
I had ex parte communication discussing the agreement with Councilperson Carr and City Attorney.
I received an email last night that I just seeing now, or I would have mentioned it, from someone who also sent a letter in. And
Okay.
the email to me just said, I'm not going to be here. I got caught in weather. My communication with them, they never asked me to take a side or do anything. They just,
Yeah, let me just respond to this letter if I could. It's the Bonita Bay resident who expresses concern about groundwater. When the DRGR was created, the state didn't have water supply planning, and there was no linkage water supply planning with local comp plans. Since the DRGR was created, all of the different areas of the state are required to have water supply planning. So here, we're under the Lower West Coast Water Supply Plan, and when the Water Management District updates the water supply plan, the local governments are required to update their comp plan to be consistent with that. I think it's part of the pending ERA amendments, or the last one, I'm not sure.
We already.
But I know the city's mindful of it, and you're in the process of complying with that. And so we know where the future wells are based on the water supply plan, and this property does not impact future water supply, just for the record.
is there anything further from the city? Is there any rebuttal from the,
No, sir.
anybody want to say anything before we begin our deliberations? Does anybody want to speak from the audience?
I think they're all involved.
Okay.
Well, and let me just say this, we've all represented minds where the public was highly agitated, animated, and in prolific attendance. The last one I had was 46 members of the public. I don't know how many were at the last one you had, but
Probably more than that. It was the first mining hearing I've ever been to where no members of the public showed up.
so I think that speaks volumes as to the communication with the community.
We're very apathetic.
Okay, is there anything further from anybody else?
Not from the city, no, sir.
Okay. What is the wish of the zoning board? Any discussion first, or anybody want to make a motion, or what is your wish?
I'll make a motion, Mr. Chairman, and we accept it what staff recommended and what applicant recommended. Give them the go-ahead, as far as I'm concerned.
Is there a second?
I'll second.
Second it.
There's a second discussion.
I'd just like to read something from the applicant's own request on page 3, because I think this is important, and I think it probably plays into what comes next, and why I would support this with or without what comes next, actually. Expanding the limits to extract to the fullest extent will decrease pressure on other properties seeking new entitlements as demand for the resource increases. So we already have this mine here, and if we could have this mine prevent more of these from having to be created out in the GR areas or open space areas, I think that's a good thing. So with that, as my rationale for going forward with this, I'm prepared to support it as well.
Any further discussion? So there are two questions presented that we'll take in order. The first question is, should the mining period be extended to 2041?
I believe the motion was to approve
Approve the whole thing.
the whole thing.
And I don't think we have a whole lot of choice about that. That's already done by other entities. We're just putting a stamp on it.
But there are two separate questions. You could vote yes on one and no on
Well,
the
it's
other.
one- But it's one application.
So if we wanted to vote, if someone wanted to vote yes on one and no on the other, they'd have to vote no on this motion. Is that
Correct.
what you're saying?
As it's laid out.
But we can't break it down. Everybody agree to that?
Unless you withdrew the motion and made a different motion.
David, do you have anything to say on that point?
Thank you. Don't be bashful, Dave.
I think if a majority of the board wanted to address the extension, you certainly have the ability to say the motion is a different date. But I think the motion is up or down unless you amend the motion as it currently stands.
We could move to amend.
And I would submit there has to be competent, substantial evidence in the record to support a different date.
I didn't get that.
Yeah, I mean, yeah, I would agree with you. I mean, how would we set a different date? We could deny it, but I don't think there's anything in the record
Fudgy.
to suggest that we could set a different date. I would agree with you.
I would agree as well. Right now, I don't believe you
So-
have any competent, substantial evidence in the record to alter the date from what the applicant has requested.
Okay. So the motion is to approve the application with the conditions placed on it by the city.
Correct.
Correct.
You have a first and a second.
Is there any further discussion? Would the clerk call the roll?
John Konzakowski,
Yes.
Robert Inserpi, Roger Brunswick, Barbara Craig, Chairman Kurlander,
No.
Russ Wynn.
Yes.
Okay, thank you very much.
Motion to adjourn.
Thank you.
That-
Motion to adjourn.
Yes.
So moved.
Is there anything further to come before the zoning
Next
board?
meeting, do we have anything on our first, next meeting,
Oh,
staff?
Do we have anything, staff, that, for a January meeting, do we have any issues coming from?
Nothing in January.
No, I don't think so. Right. Thank you all. Thank you very much.
Amazing how we never have anything in